I'm sorry, Council, for coming late. We have virtual sitting, so we'll start with the virtual sitting before continuing with the normal physical sitting.
As a cause, please.
Can you check the details of the word? Okay.
The adoption first. Since this is adoption.
Yes.
Tuesday, actually, Thursday, 16th day of June 2022, before his lordship, Honorable Justice Sanusi Kado presided. Number NICN CA 15-2019 between Victor and Yogo and the Film House Limited. My lord, the parties are.
Yes,
with profound respect, my lord, Leonard,
yes.
Leonard Anyogo Esquire, with PF Esquire, my lord.
Are you appearing for who?
My appearance is for the claimant. I am with PF Asukwo Esquire, my lord. For the claimant.
Okay.
PF Asukwo Esquire.
Yes. Yes. Any other appearance?
The Lord.
Yes.
Agba Emujeze.
Who?
Agba Emujeze.
Abba.
Emujeze. Emujeze spells E-I.
E-I-L-A.
J-E. My humble appearance is J-E-Z-E. My humble appearance is for, yes, my lord. My humble appearance for the defendant. With me is my learned friend.
Yes.
Okay.
Appearing with who?
Ibiroke Idowu. Ibiroke spells
Ibiroke Idowu.
Yes, my lord. Ibiroke Idowu.
Yes.
Defendant. My lord, the matter is for adoption of final written addresses. However,
yes,
we have a bit of
you have what?
Before we proceed with the adoption.
You have what?
Housekeeping.
Okay.
We have a motion for
not for
that.
Okay. Have you served it on the other party? Have you served it on the other party?
Yes, my lord, we have served the claimant's counsel.
Okay. When was it filed?
It was filed on the 19th day of May, 2022.
Yes.
My Lord, the motion is dated the 19th day. May I proceed, my Lord?
Yes.
Okay, thank you. The motion is dated the 19th day of May 2022, and it seeks in the main an order of this honorable court, extending the time within which the applicant may file their final written address, and an order deeming the said final written address as properly filed and served. On the face of the motion, there are 5 grounds for this application, and the application is supported by a 10-paragraph affidavit deposed to by Oliver Osai. And in support of the motion is a written address dated the same day. We are relying on all the affirmings in the affidavit and the arguments in the written address in order
Mr. Anyobo, are you objecting?
My Lord, our response to that is strictly on your discretion. However, my Lord, the defendant has not done what they need to do in terms of payment of the penalty. And my Lord, want to leave it at the discretion of the court because this motion and their final written address is actually brought against the rules of court. But we don't want to drag the matter, but just to point to the fact that they had completely negated the rules of this court by bringing this motion at this time, and the motion is not in tandem with the rules. So, but we'll leave it at the discretion of the court to look at whether the court can use its own discretion to allow it or not, my Lord.
What is that is not in tandem with the rule, with the rules?
My Lord, they haven't paid the penalty for late filing. It's not demonstrated.
They have paid penalty. They have paid 7,700 as penalty.
Okay, my Lord. My Lord is not demonstrated on our own copy.
Okay.
Yes, my Lord. My Lord, we'll leave it at the discretion of the court. My Lord, the motion is that what this motion is seeking to cure is that we have raised this objection or we have raised this issue in our own address because they have failed to file within the 21 days and we waited endlessly. And then we went ahead to file our own written address since on the 9th of May because due to their own failure, we have raised this same issue in our own final written address. So my Lord, I'm sure my Lord when my Lord will be going through, when we are finally adopting, my Lord will be going through this our reaction. So they are reacting after we have raised this issue. So
Counsel.
Yes, my Lord.
Counsel, if I grant them extension of time, it has cured whatever defect that is in the motion or in their processes. If I grant them extension, that has cured all the lapses for not filing within time.
Yes, my Lord.
So you are arguing will go to nothing, and the grant of the application date will start to running from today.
Very well, my Lord. My Lord, we'll leave it at your discretion, my Lord.
The application is granted as prayed.
As the court pleases.
As the court pleases, you are most grateful.
You're welcome. Yes. Yes.
The defendant has filed its final written address.
No, sit down. Don't worry. No need for you to stand up.
I'm not just addressing.
Yes.
Because so, thank you, Lord.
Yes.
Okay. The defendant's final written address, and in it, the defendant has carefully analyzed the case and raised one issue for determination by your lordship. We hereby adopt all the arguments canvassed in this address and urge your lordship to dismiss this suit with substantial costs.
Yes.
Well, we just want to bring a few points to your lordship's notice.
Yes.
The first, my lord, is that the second defendant, it is on record that at the beginning of this suit, we filed an application to strike out the name of the second defendant and one other defendant was the third. However, your learned brother refused to strike out the second defendant's name. But now the second defendant has left the employment of the first defendant.
That's what.
She has left the employment of the first defendant. She has gone in search of greener pastures. So I wonder what will happen to her status as a defendant in this suit. Because whatever acts that she may have carried out were done pursuant to her employment. We just want my lord to be aware that she doesn't work with the defendant again. So that's number one. But we'll now go straight to the issues before your lordship. And the first thing we want to talk about, my lord, is wrongful dismissal. The claimant has the claimant for a case of wrongness. What is he talking about? You know, because in an employer and employee relationship, the relevant document is the contract of employment.
Yes.
And we submit to the law that there's no contract of employment before this court.
No contract of employment has been what?
Reported in 2001, 6 Nigerian monthly law reports, Part 708, pages 236 to 237.
Have you not cited it in your? Have you not cited it?
This is submitted on this, so I don't know.
Unfortunately, my lord, it's not cited in our address.
So
this
please
was
save
something we came
time.
across
You have
when we were.
save time. Counsel.
No, it's not in our address, my lord. It's not there. The authorities are cited. They are just citing only the authorities this morning, and they are not in our address.
What you will do if you have gotten them this morning, what you have done, you should list them out, send a typed copy to the court and also to the other party.
Exactly.
Very well.
I hope you
We'll do
get
that.
this.
We'll send it to the court because these authorities are apt and go to the root of this matter. It will further aid your lordship in dismissing this suit in the entirety. If you have my lordship or your lordship directly, we will not go ahead with our just urge my lord to dismiss things with our final address. We are grateful, my lord.
Okay. Okay. Yes, Mr. Anyobe. You have muted yourself. Unmute yourself.
Thank you, my lord.
Yes.
My lord, the claimant had filed his final written address on the 9th of May 2022.
Yes.
And seeks to adopt all the arguments canvassed therein.
Yes.
Yeah, my lord, two major issues were raised by the claimant.
Yes.
The first is whether there is existence employer-employee relationship.
Yes.
Which we answer in the affirmative. That was also confirmed by the defendants that, that the claimant is their employee. And that presupposes the fact that there is terms of agreement, terms of employment relationship agreement.
Yes.
My lord, we quickly want to draw my lord's attention to the issue just raised, that the second defendant has left the employment of the first defendant.
Yes.
My lord, it is of no moment. Whatever act that the second defendant did was done during the employment she had with the first defendant. So the first defendant cannot exculpate herself from the fact that the second defendant has left the employment after the act has been done. So, my lord, we just want the court to take notice of that, my lord. My lord.
Yes.
Secondly, my lord, the onus of the termination of employment of the claimant is principally hinged on the fact that on the allegation of crime, by the claimant. My lord, we are holding very firmly to the tried position of law that where there's an allegation of crime, it is not the ipsi dixit, or it's not what the defendant says that amounts to proof of it. It is what the law says, and the proof is beyond reasonable doubt, my lord. There's no way during this trial that an investigation report of a criminal nature was presented before this court. There's no police report. There's no federal high court report, because in this case, my lord, we've stated it, just a summary of what we stated, my lord, that the copyright violation that they are complaining about, they ought to have reported that matter to the security agencies to be investigated, and possibly the claimant ought to have been charged before the federal high court, because it's only the federal high court that has jurisdiction to look at copyright violation they complain about. They have also not denied the fact that the claimant is entitled to benefits. They have not denied it. They have stated that the claimant is entitled to benefits, but that the benefit was withheld because of copyright violation, which is a criminal offense. My lord, we stated plethora of authorities in our final written address that we don't want to bore the court. But the government is that an allegation of criminal impute has to be proven beyond reasonable doubt. It does not lie in you becoming the accuser. The defendant is both the accuser and the judge in a criminal allegation against the complainant, my lord, against the claimant.
Yes.
My lord, we have proven, the claimant has proven that there exists an employee-employer relationship, which is not in doubt.
Yes.
It's also proving that he is entitled to benefits.
Yes.
But that the only reason that the benefit is being withheld or was withheld was because of the allegation of criminal of copyright violation. That is the gross of this matter.
Yes.
And so, my lord, we are holding that allegation has not been proven before this court by the relevant authority, neither has it been taken to the federal high court to adjudicate on that matter. And that we are saying that the defendant cannot be the accuser and the judge in a criminal trial.
Have you read
With all respectfully, claimant, looking at the circumstances
on this issue of crime, have you read Yusuf versus UBA? Have you also read Arinze versus First Bank? I say, have you read Arinze versus First Bank and Yusuf versus UBA?
Union Bank, my lord. Yusuf against Union Bank, my lord. Those are the authorities who wanted to bring forth to your lordship attention. We are grateful for your lordship wisdom.
Yes.
Ayobo, go ahead.
Mr. Ayobe.
My lord, if thy learned friend is relying on an authority that has not been cited, he should forward it to us. We'll look at it, because I don't know what specific authority is talking about?
No, I'm just raising. I ask you, have you read these two cases I mentioned? He is not the one. He was not the one raising them. I didn't know that he is going to send them, but I know the authorities exist.
Okay, my lord.
That's why I ask you, have you read Arenze versus First Bank and Yusuf versus UBN? Yes, you can go ahead. Save time. I have so many cases.
Okay, yes, my lord. My lord, the summary of our matter, of our case,
Yes.
is that the defendant cannot hide on an allegation of crime that is not proven to deny the benefit that they said it exists. They accept it exists to the claimant, my lord.
Okay.
I urge that you grant the release sought by the claimant. My lord, that is our position. We respectfully hold so.
It's all right. Let me see your diary.
The 3 months expired on the 16th of September.
No.
You can make it first week of October.
You say?
First week of October.
Good. It to be delivered before 90 days. No, I don't want to take any other adoption. Let me know what the adoptions that we have.
Yes, ma'am.
Because to take any adoption. Yes, counsel, the 90 days within which I'm to deliver this judgment will elapse in September, and it will fall within the period of vacation. So the date I'm going to give you for the judgment will be during vacation.
Very well, my lord.
So it is going to be virtual. We will send the virtual sitting ID to you. You join virtually for the judgment on that day.
As the court pleases, my lord.
This case is hereby adjourned to 8th of September 2022 for judgment to be delivered virtually.
As the court pleases.
You are very grateful.
NIC 2016.
My lord, I'm most grateful.
You are welcome.
Thank you, my lord.
And University of Port Harcourt Teaching Hospital. My lord, the claimant is absent. The defendant presented. Your name, sir? Amarachi.
Oh, you should be looking at me before you start because I am writing on also somewhere. Who is present?
The claimant is absent. The defendant is presented. Your name? Amarachi Yemaguga, legal officer of the defendant.
Appearance. Appearance. Appearance, no legal representation.
Yes, my lord.
With respect, my lord. I am E.A. Anika.
E.A. Anika.
Yes, my lord, I appear for the defendant.
Yes. Any other appearance? Any other
I appear
appearance?
for the claimant.
Yes, your name?
Hello, sir.
Yes.
J.N. Wale. I appear for the claimant, sir.
J.N. Wale for the claimant.
J.N. Wale. I humbly appear for the claimant, sir.
Yes, I have recorded you.
Yes, sir.
This matter is
Yes,
for
sir.
judgment. The judgment will be read virtually.
Yes, sir. Yes, sir. Bye, sir. This is the man I cross. The defendant's witness.
Yes, the judgment of the court goes like this. This is a transferred matter from the Federal High Court, Port Harcourt Judicial Division, as per order of transfer, dated 18th day of May 2012. The claimant in this case commenced this suit by the writ of summons filed on the 3rd of December 2009 at the Registry of the Federal High Court of Nigeria, Port Harcourt Judicial Division. Upon transfer of the case to this court, parties were ordered to refile their processes to be in line with the rules of this court. In furtherance of the order of the court, the claimant on 30th day of June 2016 filed a general form of complaint dated 14th day of June 2016, wherein he pressed the court for the following reliefs. One, a declaration that the plaintiff's employment with the defendant is extant, as the period of suspension is regarded as period of service. Two, a declaration that the continuous suspension of the claimant from his duty without compliance with federal government public service rules, regulation, procedure for discipline in the federal public service. Three, an order directing the defendant to recall the plaintiff to his duty as his employment with the defendant is extant till date. Four, an order directing the defendant to pay the plaintiff all his salaries, entitlement, and benefits accruable to him from the date of suspension till date. Upon being served with the general form of complaint, the defendant on the 12th day of July 2016 filed its statement of defense. On the 12th day of April 2018, the defendant was granted leave to amend his statement of defense, dated and filed on the 20th day of February 2018. In furtherance of the leaves to amend the defendant to amend the statement of defense, the defendant on the 12th day of April 2018 filed a clean copy of the amended statement of defense. On the 10th of November 2021, the claimant testified as CW1 in proof of his case. CW1, after identifying his witness statement on oath, adapted it as his evidence in this case. CW1 also tendered documents which were admitted in evidence and marked as exhibit accordingly. CW1 was cross-examined by counsel for the defendant. Thereafter, he was discharged. The defendant called one Amarachi Ehemagu, who testified as DW1. DW1, after identifying her witness statement on oath, tender documents which were admitted in evidence as exhibit. DW1, after giving evidence in chief, was cross-examined by counsel for the claimant. The case of the claimant. The claimant joined the services of the defendant in July 1983 as a driver in the transport department of the defendant. The claimant served in various departments of the defendant before he was attached to drive Costa bus with registration number RB 5685687A, which was attached to the NASU, that is non-academic staff union of the institution. According to the claimant, on Friday, September 1988 at about 6 p.m., he was given the sum of 240 naira by Mr. Augustine Ogwogwale, and he was orally authorized by Mr. John B. Ikanta and Mr. Augustine Ogwogwale, who were the chairman and treasurer of NASU, to on Saturday, 10th of September 1988, send the Costa bus for repairs in terms of buying tires and welding of hydraulic pipe using the sum of 240 naira. However, in the course of taking the Costa bus for repair, the claimant was involved in an accident, consequently upon which the claimant was suspended from work pending investigation of the matter. According to the claimant, he continued on suspension. His continued suspension has been without the administration and management of the University of Port Harcourt Teaching Hospital granting him any audience to defend himself or cause a representation to be made on his behalf. The continued suspension has been without compliance with the federal government public service rules and regulations and procedure to be adopted in taking decision to mete out disciplinary action to the defaulting employees. The claimant made frantic effort to have the authority of the defendant to recall him back to his work or cause a thorough investigation of the matter, but to no avail. The claimant stated that some drivers were involved in some kind of misconduct, but they were pardoned without any punishment or caution as a result of persuasion and entreaties of Chief A.K. Bogo and Mr. Aworabi due to their nepotism and selfish interest in the matter. The non-academic staff union NASU of the teaching hospital, under whose control the Costa bus was, also made frantic effort to ensure that the claimant is recalled back to work after promising to repair the same Costa bus vehicle that was damaged in the course of the accident. There was no compliance with the regulation on taking disciplinary measures under the public service rules. The continuous suspension of the claimant is unlawful and the claimant has suffered untold hardship. Therefore, that's why the claimant instituted this action to have his suspension lifted and recalled back to his work. The case of the defendant. For the defendant, the claimant was an employee of the defendant until 1988 when he decided to commit gross misconduct by using the bus assigned to him for official duties for private use of conveying his wife to see her mother at Iguruta, a situation which led to this engagement of the claimant from service of the defendant. According to the defendant, the claimant was not asked to go and repair the vehicle in question, but was asked to go and buy a new tire on Friday, 9th of September 1988, but returned to state that the price of the tire had gone up by 885 naira. The claimant was then asked to leave the vehicle for the defendant to provide the balance to enable him to replace the bad tire. But unknown to the defendant and without its authorization, the claimant embarked on a frolic of his own, especially on non-working day, Saturday. He embarked on a jolly ride by taking his wife to Iguruta, where he was involved in an accident and damaged the bus. The defendant advised that the claimant was suspended and he had since ceased to be staff of the defendant. The claimant was given opportunity to state his case. As a result, the claimant made a formal presentation to the management of his letter dated 13th day of September 1988, wherein the claimant admitted guilty. Having admitted guilty in the correspondence to the management dispensed with the need to summon the claimant to repair the boss, to summon the defendant to appear before the board of the defendant. There is no need to defend himself, as there is nothing to defend in the circumstances. It is further stated that the claimant's suspension came after the management had heard from the claimant precisely on the 22nd day of December 1988 and not before. The ASU wrote the defendant stating that the union will assist the defendant in putting the boss back into use, and pleaded that the claimant be reinstated. The defendant replied to the union letter by the letter dated 5th day of January 1999, dated 18th of April 1990, stating that the defendant management had agreed to give the union and the claimant 6 months to enable them put the bus back into use, or else the claimant be terminated thereafter. The defendant advised that between the 18th of April 1990 to 3rd of December 2009, when this action was filed, is 19 years, 7 months, 15 days, more than the 6 months agreed by the parties. The defendant stated that the claimant's reply to the effect that the said Costabos was registration number RB 5687A was on the 8th of June 1990 sold through action to Director Administration, Mr. E.T. Aworabi, while negotiation was still on, has not been proved. By this state of affairs, according to the defendant, the claimant course of action accrued on the 8th day of June 1990, but the claimant failed to commence this action until 3rd of December 2009, a period of over 6 years. A period of over 6 years. The defendant did not investigate because the claimant admitted that he took the bus on a frolic of his own on a non-working day. The defendant advised that the claimant has ceased to be a staff of the defendant more than 19 years ago. The defendant denied that Mr. Elias or Polifo or any other person for that matter damaged any vehicle and was not punished. The defendant insisted that the claimant employment was terminated and the civil service rules were not breached. The claimant has been involved in several accidents prior to the accident leading to this suit. In some cases, claimant was buried, in some others not buried. The defendant stated that 3 days after resumption on duty, the claimant earned a query for scratching beetle car belonging to the defendant. The claimant did not have an unsatisfactory job record with the defendant. This was communicated with the claimant via letter dated 15th day of May 1985. A reply to the amended statement of defense, the claimant insisted that he was authorized to carry the bus by Mr. John B. Ikata and Augustine Ogogwale, who are the chairman and treasurer of the NASU and who are in charge of the repairs and maintenance of the bus. The claimant also stated that the 240 naira given to him is enough to buy tire and repair the hydraulic pipe. The claimant was given a written authority in a paper by Mr. J. Ekanta, which enabled him to collect the said vehicle. The suspension letter was issued to the claimant pending investigation of the matter, which investigation has not been concluded till date. The claimant did not admit or plead guilty of removing the vehicle without authority or authorization. The intervention of NASU was because claimant is a member of NASU. When NASU and management agreed that the vehicle be put in good condition, within 6 months, the claimant and NASU commenced repairs, but the management of the defendant, headed by O.R. Long John, aggressively and angrily stopped and auctioned many vehicles, including the said bus. When the agreed 6 months has not expired, the defendant auctioned the said bus to Mr. Iti Aworabe on the 8th of June 1990. The claimant wrote to the defendant in a letter dated 18th day of June 1990, asking the management to allow him to continue his job as the vehicle has been auctioned while it was under repairs. The said letter was never replied by the defendant. The submissions of the defendant, the counsel for the defendant formulated 2 issues for resolution. One of the issues is a preliminary objection on limitation law. I have reproduced argument of counsel for both sides concerning the issues formulated. I will skip reading the said submissions. I go to the submissions of the claimant. The claimant formulated 3 issues for determination. The 3 issues have been captured in the body of the judgment, as well as the argument canvassed by counsel in support of the 3 issues formulated for resolution. I will skip reading the submission. When counsel got the hard copy, they will have opportunity of reading the submissions which have been reproduced and captured therein. I now go to the decision of the court. I have considered the processes filed in this suit, the evidence laid by parties, as well as the written and oral submissions of counsel for both parties from the pleading, written statement on oath, and oral testimony of parties. 2 issues can be discerned that calls for resolution. They are: 1, whether from the pleading file on the totality of the evidence or record the claimant's action was statute barred. 2, whether the claimant has proved entitlement to any of the reliefs being sought from the court. I start with the issue 1. The defendant had, in the amended statement, before delving into the main issues, I need to comment on the use of the plaintiff by the claimant use of the plaintiff instead of claimant by the counsel for the claimant. The rules of this court categorize parties as claimant and defendant and not plaintiff. Counsel shall therefore note, in case of future filing of processes before the court. I now go to the issue 1. The defendant had in amended statement of defense in paragraph 12B raised issue of limitation of law. According to the defendant, the claimant's course of action approved from 8th day of June 1990, but the claimant failed to commence this action until 3rd of December 2009, a period well over 6 years stipulated by law. According to the defendant, from 8th day of June 1990, when the claimant's course of action in this suit accrued, on the 3rd of December 2009, when this suit was initiated, instituted at the Federal High Court, is a period of 19 years. This contravenes the provisions on the limitation law and the Public Officers Protection Act. Counsel insisted that this suit offend the provisions of the limitation law, which provide for claim to be brought within a period of 6 years of the occurrence of the injury, loss, or damage for action based on contract, such contract of employment as in this case. Counsel for the defendant also refers to Section 2A of the Public Officers Protection Act and submitted that the claimant suit was caught by Section 2A for having not been instituted within 3 months as required by law On this submission, counsel relied on the case of Ibrahim versus Judicial Service Committee of Kaduna State, reported in 1998, 14 Nigerian Law Report, part 584, page 1. Counsel for the defendant also made reference to Exhibit C8 and argued that the act complained of is not of continuous of injury or damages to bring it within the exceptions provided by the law. Counsel posited that by the Exhibit C8, the claimant has been told that his employment would be terminated upon expiry of 6 months should the claimant fail to repair the defendant Costa Boss with registration number RB 5687A. The counsel for the defendant concluded his submission that by submitting that the claimant's action is statute bar and the court lacked jurisdiction to entertain same. Counsel relied heavily on the case of Ibrahim versus Judicial Service Committee, SUFRA. For the claimant, it was submitted that this suit was not caught by limitation law in all its ramifications, as the suspension of the claimant from his duty is a continuous injury or continuous of damage, same running from 22nd day of December 1980 till date, as there has been no vacation of the suspension, nor has there been any termination letter issued to the claimant. Counsel contended that this case is not affected by Section 2A of the Public Officers Protection Act or any other limitation of action act or any law, because the suspension of the claimant contained in Exhibit 3, being suspension letter of 22nd day of December, runs till date without any letter issued to the claimant to terminate or dismiss the claimant from service. On this submission, reliance was placed on the case of Aremo 2 versus Ade Kanyip. Counsel also argued that there is a mistake or an error in the dependent approach made of the dealing with the claimant by way of disciplinary measures. This is because the defendant did not issue any query to claimant on the accident of 10th day of September 1988, as the queries of Exhibit D7 and D8 tendered by the defendant were a result of incident that happened in 1983, and not on the incidents that happened on the 10th of September 1988. It was also the contention of counsel for the claimant that the chief medical director did not suspend the claimant for not more than 3 months and direct a committee to consider the case and make recommendations as to the appropriate action to be taken by the chief medical director. Counsel submitted that there is non-compliance with Section 10, subsection 1A, B, and 2 of the University Teaching Hospitals Reconstitution Act, ETC Act. Counsel submitted that the mistake or error regarding the law has stopped the operation of limitation law. Thus, this case is not caught by any limitation law. Generally, where the law provides time for the bringing of an action within prescribed period, irrespective of a course of action accruing to any party, proceedings shall not be brought after the time so prescribed by the statute had expired. Therefore, an action brought outside the prescribed period offends against the provisions of statute and does not give rise to a course of action. Such an action is said to be statute bar. Where an action is statute bar, a party who might have had a course of action loses the right to impose the said course of action by judicial process, because the period of limitation laid down by the limitation law for instituting such an action has elapsed. Thus, the period of limitation or limitation law affects the course of action or validity of the course of action instituted outside the limitation period. It deals with the competence of the action so instituted and has nothing to do with the jurisdiction or competence of the court to decide and determine the matter. See the case of Ela Banjo versus Daoud, reported in 2003, 15 Nigerian Penal Report, part 1001, page 76. See also Idigbe versus Ade Farasi. See also Oguru versus SPDC Nigeria Limited. See also Hudson Graphic Art versus NDIC. where it was stated that a statute of limitation prescribed a period within which an action must be brought. Legal proceeding cannot be properly or validly instituted after the expiration of the prescribed period. See also the case of Idigbe versus NNPC and that of Kanyip versus NNPC. A course of action is said to be complete and time begin to run for the purpose of limitation law when all the facts necessary to institute an action are complete and when the person who can sue and the person who can be sued are easily identified. It is then that an aggrieved party is expected to file his action within the time stipulated by the limitation law. See the case of Lafia local government versus governor of Nasarawa State, reported in 2012-17 Nigerian Criminal Report, part 1328, page 94. It is pertinent here to point out that time begins to run for the purpose of limitation law from the date the course of action accrued. See the case of SPDC Limited versus Para. See Asaboro versus Palm Ocean. See also Ogunko versus Shelle. See also CPAX Nigeria Limited versus MIG4 Nigeria Limited. The law is well settled that period of limitation in any limitation status is determined by looking at the writ of summons and the statement of claim. In the case at hand, the complaint and statement of facts in alleging when the wrong was committed, which gave rise to the course of action, and by comparing the date with the date on which the writ of summons was filed. This can be done even without taking oral evidence from the witnesses. If the time on the writ of summons is beyond the period allowed by the limitation law, the action is started by. However, where evidence has been given, like in the case at hand, the court is free to look at the entire proceeding and the evidence of the parties. In applying the settled principle of law as enunciated by the above decision, a look at the claimant's complaint and the statement of fact, it will be seen that this action was instituted on the 3rd day of December 2009 by the claimant to challenge his suspension from work and also sought for an order reinstating him back to his job as a driver with the claimant. The defendant in contending that the action is started back because it was instituted in contravention of limitation law and section 2 of the Police Officers Protection Act. Now, the task to be performed by the court is ascertaining whether this suit was instituted in contravention of the laws or limitation of action. The defendant was not specific on the exact limitation law that the claimant contravened for the purpose of the institution of this case within 6 years provided by the limitation law. However, let me say here that Rivers State limitation law provides for institution of a contract or thought to be made within 6 years of accrual of the course of action, failing which an action will be started back. As rightly pointed out by the claimant, the limitation law of Rivers State has provided exception to the strict application of the law. One of such exceptions is where the course of action was deliberately concealed or an action is based on defendant's final fraud. Where relevant facts to the case of the claimant's right of action are concealed from the claimant, the operation of limitation is suspended. In such situation, time will not start to run until after the discovery of the fraud or concealment, or when the claimant could have discovered such concealment or fraud. Section 31(1)(a) of the limitation law of Rivers State is clear on this. See also the case of executors of the estate of late Abacha versus AKCP, reported in 2009, 2-3 SC Part 2, page 93 at 117 to 118. In the case at hand, the claimant was by the XBC suspended from work pending his investigation of accident that occurred while he was driving Costa Bus with registration number RB56878 belonging to the defendant. The defendant is relying on Exhibit D9, which is same with Exhibit J, to argue that the claimant's employment with the defendant has been terminated due to failure of repair of the Costa Bus. For the purpose of appreciation, the content of Exhibit D9 and J is hereby reproduced. is hereby reproduced as follows. Reference UPTH/553/volume 1/70, dated 18th of April 1990, addressed to the Secretary Non-Academic Staff Union of Educational and Associated Institutions, PPTH branch, that is University of Port Harcourt Teaching Hospital branch. It says reinstatement of Mr. Donatus Wokfe. I am directed to refer to your letter of 5th January 1990, in which you were appealing for reinstatement of Mr. Donatus Wokfe on the conditions that your union will assist in the repairs of the Costa Boss number RB 5687A. Management at its decision, management at its meeting of 3rd of April 1990 decided that your union is given 6 months deadline within which to effect repairs on the said vehicle, and that Mr. Wokfe's appointment would be terminated if this was not done. You may therefore wish to take appropriate action. J.O. Somiri, Miss, for Chief Medical Director. A similar letter was written to the claimant, see Exhibit L, the letter dated 13th day of March 1990, where in paragraph 2 to 3, it was stated thus: at its meetings of 9th of March 1990, management considered these appeals and was magnanimous enough to decide that as soon as the Costa Boss mentioned above is repaired and back on the road in good condition, you will be recalled from the suspension. The purpose of this letter, therefore, is to inform you that you will be recalled back. Only when the Costa Boss is in perfect working condition. End of quote. It is clear from the content of the above exhibits that the defendant has evinced the intention to recall the claimant back to his job when the Costa Boss with which the claimant was involved in an accident is repaired and put back to the road. This also means the suspension of the claimant continued. The claimant has averred in his reply to the defendant's amended statement of defense that the Costa Boss which the claimant and NASU are to repair and put into use within 6 months had been auctioned by the defendant on the 8th of June 1990 to Mr. E.T. Aworabi, the Director of Administration of the defendant. See Exhibit M, letter of 18th day of June 1990 by the claimant to the Chief Medical Director, leading for his recall from suspension since the vehicle has been sold to a director of the institution. It is to be noted that the defendant has not tendered any evidence by any letter of termination, dismissal of appointment issued to the claimant by the defendant. The content of Exhibit J and Exhibit D9 are very clear and unambiguous. They say what they say. The exhibit only indicated that suspension of the claimant can only be lifted and the claimant recalled back to his job when the Costa Boss is repaired by the claimant and NASU. Exhibit J and D9 cannot in all sense of responsibility be interpreted to mean termination, dismissal of claimant's employment. I hold that as at the date of this exhibit, there was no termination of appointment of the claimant. The claimant remains employed in the employment of the defendant. He was never terminated by Exhibit J and D. If there had been any termination, the defendant should have tendered the letter of termination which was served on the defendant. There is no such evidence before the court. Since there has been no termination dismissal, time cannot start to run. The reason being that suspension of employee will only amount to temporary stoppage of claimant from performing his duty, and it does not affect the relationship of the parties. See the case of Longe versus First Bank of Nigeria, reported in 2010. In any event, it is right that it is a statement of claim that discloses when a cause of action arose and limitation time usually runs after the person wrong is made aware of the wrong. Since claimant was not made aware of his termination or dismissal from service, time will not start to run as the factual stations that will donate course of action or on termination or dismissal have not been completed. See the case of Nwanko and another versus Nwanko reported in 2017 LPLR 42832 CA. Having found the claimant is still in the service of the defendant on suspension, the limitation law cannot operate to render claimant suit challenging his suspension from work statute bar. The claimant therefore is not claimant's action is therefore not statute bar. Even if the claimant suit is caught by limitation law, I am still of the view that the concealment of the termination dismissal of the claimant from his employment, concealment of the termination or dismissal of claimant from the employment of the defendant has watered down the effect of the limitation law and postponed its application on the case of the claimant. On Section 2A of the Public Officers Protection Act, the case of the claimant is well grounded within the exception to the applicability of the provisions of Section 2A of the Public Officers Protection Act, in that the action of the claimant in disengaging him from service without his knowledge is unlawful. It is an act that cannot be condoned as it is illegal, not within the purview of protection of Section 2A of the Public Officers Protection Act. It can only provide cover or shade for those public officers that acted within the confines of the law, and not those who decided to discredit the law and do things in their own way in disregard of the law. The defendant in this case decided to disobey the law and do things in their own way. Where a public officer acted ultra biased, unconstitutionally abuse his office or violate any law, his action or conduct cannot find any hiding place under the protection of the Public Officers Protection Act, as the act cannot serve or shield a public officer from being sued where he acted ultra biased or in abuse of his office, as in this case. See also the case of Mohammed versus ABU Zaria 2014-7 NWR part 1407 page 500. Public officers who in the course of his duty violated the law cannot find any protection under the law. The position taken by the court has support from the provisions of Section 10, subsection 1 of the University Teaching Hospital Reconstitution Board ETC Act, which pegged period of suspension to be not more than 3 months. The law does not recognize indefinite suspension of employee like the claimant. In view of the above exposition, issue 1 is resolved in favor of the claimant against the defendant. This suit, as it is presently constituted, being challenging the suspension, is not statute bar. I so find and hold. Issue 2, whether the claimant has proved entitlement to any of the relief sought from the court. The reliefs being sought by the claimant are well set out in the beginning of this judgment. They are for declaration, setting aside suspension for non-compliance with federal government public service rules, on procedure for disciplinary action, recalling the claimant back to his duty as his employment is still extant till date, and payment of all salaries, entitlements, and benefit accruable to the claimant from the date of suspension till date. Relief 1 and 2, which are for declarations, are the main reliefs, while reliefs 3, 4, and 5 are ancillary reliefs dependent on the grant of the declaration. This means that the court must first declare that the claimant's suspension from his employment was unconstitutional, illegal, wrongful, null, and void before it will proceed to either order for setting aside, recall of the claimant, or payment of salaries and other entitlement from the date of suspension to date. Before a court can grant declaration which the claimant is seeking, he must plead and lead evidence to entitle him to that declaration. And the admission of defendant of the claim will not relieve the claimant of the onus of proving his claim. The law is right that a party who seeks declaratory reliefs from the court must in all cases rely on the strength of his case and by the production of credible and sufficient evidence which establishes the entitlement to the declaration sought before he could seek or rely on part of the defendant's case which supports the declaration. Such claimant cannot, however, rely solely on either admission or weakness of defendant case. He must satisfy the court by credible evidence that is entitled to the right to be claimed. He is entitled to the claim. The claim for declaration cannot be granted on admission. See the case of Bello versus Iweka, Adigum versus Attorney General of your state. See also Akande versus Adisa. See Onu versus Agu. See Director SS versus Agbakoba. See Yahaya Michika. See Yahaya versus Michika. See Ayaru versus Mandilas. See also Agi versus PDP. See Dumes Nigeria Limited versus Onwakoba. See Zakala versus Edosa. See G International Operation Limited versus Q Oil and Gas Services Limited. See Mohammed versus Wamako. Ofongo versus APC, and also other authorities cited there. By virtue of section 131, 132, and 133 of the Evidence Act 2011, a party owes the legal duty and evidential burden of proving his assertion. He who asserts must prove. In the instant case, the claimant in his case owed the legal duty of proving assertion he made against the defendant on the basis of which he sought the judgment to be given in his favor. See Magati versus Odofin, DB Yamaka versus Osakwe, Adegoke versus Adibi, Giaza versus Bamboshe, Egareba versus Osagi. The claimants disgruntlement and grumble against the defendant following the accident the claimant had with the defendant's postal boss on 10th of September 1988, the defendant suspended the claimant from work with effect from 22nd day of December 1998. See Exhibit C. Suspension was done without any query given to the claimant, nor opportunity given to the claimant to defend himself. It was also about that the suspension was done in disregard of the extant provisions of the Public Service Rules 2008 and the University Teaching Hospital Reconstitution Act. The claimant insisted that he is still in service as suspension is not dismissal or termination of employment. More so, when there was no letter of termination issued to him by the defendant, he also stated that he wrote several letters of plea for reinstatement but to no avail. See Exhibit F, G, H, M, O, and P. For the defendant, the claimant who has the burden of proving his case with preponderance of evidence or balance of probability as by his pleading and evidence adduced, failed to establish his case by failing to show the rules of federal government public service which the defendant did not comply with by the defendant. It is the case of the defendant that the extant public service rules 2008, which is the revised edition of the 2007, is not binding on the claimant, since the claimant was employed in 1983 and the claimant's suspension was carried out in the year 1988. The defendant is of the view that reliefs 2 and 3 have no foundation to entitle the claimant to grant of same, since Public Service Rules 2008 is not a extant rule in operation as at the period of suspension. Or relief 1, the defendant considered that period of suspension is regarded as a period of service. Nevertheless, it is not applicable in circumstances of this case, given the fact that claimant's suspension had been overtaken by the subsequent termination of claimant's employment. Counsel contended that relief 1 is not live issue that can be determined, as it is not unknown to the claimant that his employment has been terminated by virtue of breach of conditions contained in Exhibit J, the letter dated 18th day of April 1990. From the gamut of evidence and pleadings before the court, the claimant is contesting the validity of his suspension and regarded himself to be still in the employment of the defendant. Since his suspension had terminated his appointment from the service of the for the defendant, the issue of suspension has been overtaken by claimant's employment has been terminated. Has been overtaken, has not been proved, as there was no evidence of such termination has been tendered by the defendant. The law, the term suspension in the employment context refers to state where an employee is temporarily debarred by his employer from time being from performing any of his official functions or enjoying certain privileges. In other words, it means an order of suspension of employee is issued to keep away the employee from exercise of his official functions or enjoyment of certain privileges. Suspension is not capable of putting an end to contract of service relationship without more. The relationship is only put on hold temporarily. This much has been admitted by the defendant in the final written address before the court, but it was pointed out that the suspension of claimant had been overtaken by the subsequent termination of the claimant's employment. But there was no such evidence adduced by the defendant to establish that the claimant has been employment has been terminated, and there was no evidence to show that the claimant has been informed of the termination of his appointment as being alluded by the defendant. The Supreme Court has the opportunity defining the term suspension in the case of Longe versus First Bank Sufra. The case of the claimant is that his employment with the defendant is still extant, as the period of suspension is not regarded as period of service, and that the continuous suspension of the claimant without compliance with public service rules regulating the procedure of disciplinary action in the public service is unlawful, unconstitutional, null and void, and of no effect whatsoever. It is clear from the pleadings of the claimant that his employment with the defendant is governed by Memorandum Exhibit B, which contains terms of his employment as a junior staff of the defendant, the provisions of University Teaching Hospital the Constitution etc. Act, and the public service rules It is clear from Exhibit B that claimant's employment is governed by rules and regulation of public service, governing employment of staff of his cadre in the public service. Before proceeding to further with the consideration of the issue for determination, let me at this juncture deal with the issue of which condition of service governs the employment of the claimant. The defendant has strenuously argued that the Public Service Rules 2008 is not applicable to the claimant because he was employed in 1983 and his suspension, which he is now challenging, was in 1988. From the pleading and evidence before the court, the claimant has used the Public Service Rules 2006 and that of 2008. Let me say here that use of wrong law or rules or not relying on the correct law in pressing for one's right does not deprive the party of his entitlement to the right, provided he is in law entitled to it. Therefore, the submissions of counsel that relief 2 and 3 are of no merit cannot be sustained. Failure to indicate the correct rule or regulation in making claim does not invalidate the application. Provided the relief or remedy is provided for by any written law. In the instant case, the claimants alleged citing the wrong public service rule in respect of his claim before the court will not in any way deprive him of grant of his relief if the said relief is recognized by any law. Therefore, citing or relying on wrong law and is not fatal to the claimant's case, provided the relief is within the power of the court to grant. See the case of Palobi versus Palobi. See also Olegede versus Military Administrator of Benue State. As at 1983, when claimant was employed by the defendant, the public service rules governing employment of public servant is the Public Service Rules, Civil Service Rules of 1976. These rules were revised in the year 2000, 2006, 2007, and then 2008 Public Service Rules. I have examined these rules, and it is clear to me that the amendment to the various rules did not affect the provisions of rules on disciplinary action. The content in the various rules on discipline are same. It is only the way the rules were numbered that is different. In the circumstances, whichever rules is used, the result will be the same, since the content on discipline are the same. The major rationale, noticeable difference in the various rules, are in the area of pension, gratuity, monetization, and allowance payable to staff. It is to be noted that public service rules, being rules governing conduct and procedure to be followed in dealing with issues, are like the rules of court, to which the governing rules will be the rules enforced as at the time the action is to be taken, and not when the cause of action arose. It is only where substantive law is concerned that the law applicable to cause of action will be the law as at the time of the approval of the cause of action. Thus, in an action is governed by law existing at the time the cause of action accrued, while the rules and procedure applicable are the rules when the action is being had. See the case of Dakan versus Dawan. See also Umora versus Umwabuze. See also Owata versus Anyigo. See also Aremo 2 versus Adekanye. See Iwunze versus FRN. See Rosek versus ACB. Having regard to cases cited above, I am of the view that the use of public service rules 2008 by the claimant is correct and it is sustainable. The dependent is a statutory body established pursuant to University Teaching Hospitals Reconstruction Act, being a body established by statute with power to employ and discipline its staff. The rules and regulations governing employment of the claimant shall be the University Teaching Hospital Reconstruction etc. Act or rules made thereunder. It is only when there are no rules on a particular aspect of conditions and terms of employment as contained in the Act that resort can be made to the public service rules. See Chapter 16, Section 1, 2, 3, 4 of the Public Service Rules 2008. See also Section 5, Subsection 5 and 10 of the University Teaching Hospital Reconstitution etc. Act. As pointed out earlier in this judgment, the dependent being a creature of statute with power to employ and discipline its employee in carrying out the duty taking disciplinary action against its employee, resort must be had to the provisions of the law establishing the dependent for guidance on how to go about taking disciplinary measures. In the case at hand, Section 10 of the University Teaching Hospital Reconstitution Act becomes handy. Having made ample provisions on suspension, no recourse should be made to public service rules, PRS 030406, in suspension of the dependent employment. By the Exhibit C, the claimant was suspended from work for moving boss without genuine authority on a non-working day and without a genuine reason for so doing, other than take his wife to Buruta to see her mother. The act of the claimant was said to have constituted deliberate act of gross indiscipline. The claimant was suspended pending further investigation by the management. The claimant was also by the Exhibit C informed that he should not be seen around the hospital premises as long as the suspension is imposed, unless with the prior consent of the Chief Medical Director. It is Exhibit C that regards this suit filed by the claimant to challenge his suspension from work. Therefore, this court is duty bound to restrict its consideration of the claim of the claimant to the reliefs being sought from the decision of the Supreme Court in the case of Longe versus First Bank. It is clear as the daylight that issues of suspension of employee is within the power of employer. In the case at hand by the Exhibit 10, by Section 10, Subsection 3 of the University Teaching Hospital Reconstruction Act, the Chief Medical Director of the dependent has been invested with power to suspend claimant, but there is a limitation to the period of suspension. The claimant can only be suspended for a period not exceeding 3 months. The most crucial question to ask now is, has the suspension been made in line with the extant law governing claimant's employment? The answer to this further is in the capital no. The reason being that Exhibit C having been issued in excess of the period allowed by law is ineffectual. It is null and void and of no effect. It is interesting to note that the dependent did not deny suspending the claimant, but claimed that the suspension has been overtaken by event in that the claimant subsequently had his employment terminated. To support this position, reliance was placed on Exhibit D2, which is a response to Exhibit D1 and Exhibit O, which were the request by NASU and the claimant respectively pleading for reinstatement of the claimant back to his job. In Exhibit D2, which is the same with Exhibit L tendered in evidence by the claimant. The defendant stated that claimant will only be recalled from suspension or back to work as soon as the costa bus is repaired and put back to road in perfect working condition. This was the outcome of the meeting of the management of the defendant held on the 9th day of March 1990. In another letter, Exhibit D9, addressed to the Secretary of NASU, it was stated that the management at its meeting of 3rd of April 1990 decided that the union is given 6 months deadline which to effect repairs of the vehicle and that Mr. Donatus Ope, the claimant appointment will be terminated if this was not done. See Exhibit D9, which is same with Exhibit J tendered in evidence by the claimant. It is clear as the daylight that the letter of claimant's Exhibit L and D2, the claimant was never informed that his job will be terminated if the costa bus is not repaired within 6 months. It is in Exhibit J and D9 letter addressed to Secretary of NASU that the defendant gave NASU 6 months period within which to repair the costa bus or the appointment of the claimant will be terminated. In interpretation of content of document, the court is guided by the principles of interpretation of statute, where the words of documents to be interpreted are clear and unambiguous. A literal interpretation will be applied. That is, the words will be accorded their plain and grammatical meaning. See the case of NEW Limited versus Delop Limited. See also the case of Ojo Kolobo versus Alamu. See also Olarewaju versus Governor of Oyo State. See also Egbe versus Yusuf. See Yarokun versus Adeleke. See Ahmed versus Kasim. See Egbe versus Alaji. See also Adeumi versus Ekiti State. Attorney General Ekiti State. See Ojo. See also Obi versus INEC. However, where the words in the document to be interpreted are ambiguous, the holistic consideration of the document to be interpreted becomes imperative. In this situation, the construction of the whole document will be resorted to in order to arrive at the intention of its makers, intention of the makers of the document. See the case of AG of the Federation and Abu Bakar. See also Elelu Habib versus Attorney General of the Federation. See also INEC versus Musa. See also Marwa versus Sinyako. See also AT Limited versus ADS Limited. See also Obi versus INEC Sufra. See Ojuku versus Obasanjo, etc. In applying the above principles of construction enunciated in the above cases to this suit, it will be correct to say Exhibit L, O, D2, and D9 can never be interpreted to mean letter of termination of claimant's employment. What this exhibit seeks to convey is that the lifting of the suspension of claimant will depend on the repair of the costa bus with which the claimant had accident with. The exhibit can never by any stretch of imagination metamorphose into termination of claimant's employment, assuming without considering that Exhibit L, O, D2, and D9 are interpreted to mean termination of claimant's employment. There is no doubt that the claimant in this case does not hold his office at the pleasure of the defendant or anybody at all. Rather, he holds it under the provision of University Teacher Hospital Reconstruction Board ETC Act. Therefore, the defendant, being creator of statute, cannot, except within and under the powers conferred on it by the relevant statute, creating it, act in the way it acted. The employment, retirement, and termination of employment of the claimant is governed by the University Teaching Hospital Reconstitution of Board ETC Act. See Section 5, Subsection 5, and 10, Subsection 1, 2, and 3 of the Act. This provision invests in the claimant with legal status, which makes his relationship with the defendant not one of master and servant, but that is statutory playbook, as distinct from ordinary master and servant relationship. See the case of Olanian, University of Lagos. See Falomo versus Lagos State Public Service. See Shita Bay versus Federal Public Service. See the case of Abraham Oba, University of Ilorin Therefore, for the defendant to validly terminate claimant's employment, which has statutory labor, the provisions of Section 8 of the University Teaching Hospital ETC must be complied with, as any deviation or non-compliance with the said provision will nullify the action taken by the defendant against the claimant. In any event, the claimant being a statutory employee, his employment must be terminated in line with statutory provision laying down the procedure to be followed in terminating the employment. The claimant has averred that he was never queried, and no disciplinary committee has been set up to consider the allegation level against the claimant, nor was he afforded opportunity to defend the allegation level against him. The claimant further stated that no recommendations were made by the committee to the medical director. This assertion of the claimant was not disputed by the defendant. The defendant answer was that there was no need to set up a committee since the claimant has by the XBD, which is same with XBD 3 tendered by the defendant, admitted the allegation. I do not see how the claimant will be said to have admitted the allegation level against him when no any query was issued to him on the accident. The query issued to the claimant XBD, the reply to the query XBD 8 was in 1983, while the incident that led to the suspension of the claimant occurred in 1988. The failure of the defendant to strictly adhere to the provisions of Section 10 of the University Teaching Hospital, the Construction of Board ETC Act, which requires the claimant to be informed of the allegation of misconduct against him, and a committee to be set up, and the recommendation to be made to the Chief Medical Director, to whom the law entrusts with the power of taking final decision on the recommendation of the committee. The failure by the defendant to religiously adhere and strictly follow the provisions of Section 10 of the University Teaching Hospital Reconstitution Board ETC Act has rendered the presumed termination of claimant's employment, if any, null and void. In the case of UNTHMB versus Inoli, reported in 1992, Nigerian Employee Law Report, Part 656, page 376, the Supreme Court stated that it is well established that when a statute has conferred on anybody the power to make decisions affecting individuals, the court will not only require the procedure prescribed by the statute to be followed, but will readily imply so much and no more to be introduced by way of additional procedural safeguard as will ensure the attainment of fairness. See the case of Olorun Toba versus NISA. When a statute directs that certain procedure be followed before a person can be deprived of right, such a procedure must be strictly followed. Otherwise, the court will declare void any act done not in accordance with the prescribed procedure. In the instant case, the defendant did not follow the statutory provisions, which require setting up of committee and making a recommendation to Chief Medical Director, to whom the law confers the power to remove the claimant from his employment in the institution. This neglect or failure to conform with the mandatory statutory provisions of the law for the exercise of legal authority as laid down, the non-observance in the process reaching any decision rendered the decision itself a nullity. Thus, in this case, having failed to observe statutory requirement laid down in Section 10 of the University Teaching Hospital Reconstruction Act, it is incumbent on the Chief Medical Director to make sure in taking disciplinary action against the claimant is notified with the allegation of the act of misconduct against him. The decision of the defendant to terminate employment without compliance with the laid down procedure was taken ultra biased, and the decision itself is a nullity. See Shitabe versus Federal Public Service, see Bankole versus NBC, see Olane University of Lagos, see Olaro Toba versus NISA Council. It appears to me that the defendant reliance on purported admission of fault as a reason for not setting up committee or issuing query to the claimant was based on misconception of law. The erroneous belief of the defendant that the claimant had admitted fault. Therefore, it is unnecessary to observe the conditions laid down in the University Teaching Hospital Reconstruction Act, as well as the strict observance of the rules of natural justice. The defendant breached both Section 10 and the obligation imposed upon them arising from the rules of natural justice, namely, the decision makers must act fairly, in good faith, and without bias, and must afford each party the opportunity to adequately state his case. In this case, there was a failure by the defendant to comply with all the preconditions set out in Section 10 of the Act. There was, in the circumstances, no hearing, let alone a fair hearing. See the case of Olanian. University of Lagos, see Ayetan versus Insupo, see Perepu versus University of Lagos. The decision to purportedly terminate claimant's employment without issuing a claimant letter of termination or following due process is void, and it does not matter that the decision was desirable in the circumstance, as the defendant seems to strenuously argue. The most important thing is following due process, the procedure laid down in the Act empowering the defendant to act. The courts have jurisdiction to declare invalid any act or exercise of administrative body not done in accordance with the legislative powers conferred upon it by statute under which it purportedly acted. And this is so where the order is ultra biased by reason of the patent defect or by reason of defect in the procedure followed prior to it being made. See Olorun Toba versus NASA and UTNB versus Inoli. Having found that there is no valid suspension of the claimant and there is no valid termination of appointment as claimed by the defendant due to lack of evidence of such termination, since the claimant employment has statutory labor, the claimant is entitled to be back to his job, as his suspension only temporarily stopped his work. The claimant is equally entitled to all his salaries and allowances from the date of suspension, i.e. 22nd day of December 1988 to date. However, I observe, by Rule 020810 of Section 8 of Chapter 2 of the Public Service Rules provide the compulsory retirement age for all grades in the service shall be 60 years or 35 years of pensionable service, whichever is earlier. 2, no officer shall be allowed to remain in service after attaining the retirement age of 60 years or 35 years of pensionable service, whichever is earlier. Rule 160401 has made provisions in Section 8 in Chapter 2 of the Public Service Rules on leaving of service applicable to all parastatals of government. I note that the claimant started work with the defendant in 1983. This means from 1983 to date, claimant years of service will be 39 years, which is in excess with 4 years. In the circumstances, the claimant reinstatement is from the date of suspension to year 2018 when he clocked 35 years in service. And by that, by operation of law, the claimant is deemed to have retired from service in year 2018. On the whole, the claimant succeed in establishing that his suspension was unlawful, illegal, because it was done not in compliance with the law establishing the defendant. It was in violation of the clear provisions of the law. It is the claimant, as stated earlier, has also established that therefore he is entitled to be reinstated back to his post. But the reinstatement shall be from the date of suspension, that is 22nd day of December 22nd day of December 1988 to 2018, when he would have clocked 35 years of age and deemed to have retired from service by operation of law. He is also entitled to get all his salaries and allowances from 22nd day of December 1988 to year 2018. In the circumstances and for avoidance of doubt, the defendant is hereby ordered to reinstate the claimant back to his post from 22nd day of December 1988 to 2018, when he is deemed by operation of law to have retired. The defendant is also hereby ordered to pay all the salaries and allowances of the claimant from 22nd day of December 1988 to year 2018. I also award 1 million naira damages in favor of the claimant against the defendant. The defendant is hereby ordered to settle all the monetary claims, all the monetary aspect of this judgment within 30 days, failing which 10% interest per annum shall be applied. That is the judgment of the court. Judgment entered accordingly. What the next case?
Suit number NICM CA 29/2019 between Mr. Efi Okokon Asupwo and Lafarge African PLC. My lord, parties are absent.
Any appearance? Yes. Christopher Utu. Yes. BA. KU. Appearing for who?